Eleanor Whitfield was 68 years old when she found the heron. It was floating on its side near the reeds, wings splayed like a broken umbrella, its feathers slicked with something that caught the morning light in oily rainbows. Eleanor had taught high school biology for 34 years in the small town of Ashford Hollow, and in all that time, she had never seen anything quite like it. She didn't scream, she didn't even flinch. She simply set down her thermos of coffee on the dock railing, pulled a pair of nitrile gloves from her jacket pocket, because Eleanor Whitfield always carried nitrile gloves, a habit from decades of dissection labs, and waded into the shallows to retrieve the bird. This wetland, 11 acres of marsh, reed beds, and slow-moving creek that the locals called Sparrow Hollow, had been in Eleanor's family for 3 generations. When she retired 6 years earlier, she'd turned it into something between a nature preserve and an open-air classroom, inviting local students out every spring to catalog frog egg masses, measure water clarity, and ban migratory birds. She'd done it for free. She'd done it because she loved it. She had also, without telling a single soul in Ashford Hollow, been recording water chemistry data from that wetland every single month for 29 years. It had started as a classroom exercise, a way to teach her students what longitudinal data meant: dissolved oxygen, pH, nitrate levels, turbidity. Every reading logged by hand, then later by spreadsheet, cross-checked and countersigned by whichever student happened to be holding the clipboard that day. 29 years of baseline data, verified by hundreds of teenage witnesses who had long since grown up and scattered across the country. Some of them now doctors, engineers, lawyers, and in at least one case, a senior scientist at the Environmental Protection Agency. Eleanor did not know yet that this quiet habit was about to become the most valuable evidence file in the state's history. She drove the dead heron, double-bagged and iced in a cooler, to the extension office at the state university 2 hours away. The necropsy came back 9 days later. Massive hepatic and renal failure. Toxicology flagged elevated concentrations of a chlorinated industrial solvent, along with heavy metal contamination, cadmium and chromium, well beyond anything found in nature. The lab tech on the phone sounded almost apologetic. "Mrs. Whitfield, whatever's in your water, it's not agricultural runoff. This is industrial. Somebody's dumping." Eleanor looked out her kitchen window, past the fence line, toward the gleaming steel roofs of Halden Agrochemical's processing plant, less than 400 yards upstream from her property. She smiled, not because she was pleased, but because, for 6 years, she had been waiting for exactly this moment, and she already knew precisely what she was going to do about it. Halden Agrochemical had operated the plant on the edge of Ashford Hollow for 11 years, manufacturing fertilizer additives and industrial solvents used in seed coating. It was owned by Gordon Halden, a silver-haired third-generation industrialist who had inherited the company from his father and had spent the last decade quietly cutting corners to protect quarterly earnings. Gordon Halden did not think about Eleanor Whitfield very often. When his plant manager first mentioned some retired schoolteacher filing complaints about dead birds, Gordon's response, according to an internal email later entered into evidence, was simple. "She's 70. She teaches biology to teenagers. What's she going to do? Give us a pop quiz?" It was the kind of arrogance that would cost his company billions. What Gordon Halden did not know, what almost nobody in Ashford Hollow knew, was that Eleanor Whitfield had spent the last 6 years of her retirement doing far more than birdwatching. 3 years before the heron washed up dead, Eleanor had noticed survey stakes appearing along the property line between her land and the Halden plant. Curious, she'd made a call to the county assessor's office, using the same patient, disarming voice she'd once used to calm down anxious parents at parent-teacher conferences. She learned that Halden Agrochemical had inquired about the feasibility of expanding its wastewater discharge permit, an expansion that would require access to, or acquisition of, the wetland on her property. Most landowners would have felt afraid. Eleanor felt validated. She had spent her entire career teaching students that water doesn't respect property lines, and that industrial polluters count on exactly one thing: that nobody watching the wetland has proof, patience, or resources sufficient to fight them in court. So Eleanor set out to make sure that if this fight ever came, she would have all three. She filed for and was granted a permanent conservation easement on the property through a regional land trust, making the wetland effectively impossible for any company to acquire, buy out, or quietly absorb, no matter what pressure was applied to her personally. She registered the site as an official long-term water quality monitoring station with the State Department of Natural Resources, which meant her monthly data collection was no longer just a retired teacher's hobby. It was now, legally, part of the state's own environmental record. And she reached out to a former student, a woman named Dr. Sarah Bennett, now a senior toxicologist with the regional EPA office, simply to ask, in the most casual and grandmotherly way imaginable, whether Sarah might be willing to look over some of Mrs. Whitfield's old water samples sometime, just for fun. Sarah had said yes immediately. She had never forgotten the woman who'd stayed after school 3 nights a week to help her pass chemistry. None of this had cost Halden Agrochemical a single sleepless night. As far as Gordon Halden was concerned, the wetland behind his plant was an empty patch of mud and weeds owned by a harmless old lady who liked birds. He was about to learn how wrong he was. 2 weeks after the heron's necropsy results came back, a black SUV rolled up Eleanor's gravel driveway. Out stepped a man in an expensive gray suit, holding a leather folio and wearing the practiced, gleaming smile of someone who had never once lost a negotiation with a private landowner. His name was Preston Vance, outside counsel for Halden Agrochemical, and he had been sent to make the whole dead bird business disappear quietly, cheaply, and permanently. "Mrs. Whitfield," he said, extending a hand she did not take. "Halden Agrochemical takes environmental stewardship very seriously. We'd like to offer you $40,000, effective immediately, in exchange for a full release of any claims. Plus, of course, our sincere condolences about the bird." Eleanor invited him in for tea. She always believed you should be polite to people, even people who were trying to rob you. She listened to his entire pitch. She nodded in all the right places. And when he finished, she folded her hands on the kitchen table and said, "Mr. Vance, before I answer, I'd like to show you something." She led him out to a small mudroom off the kitchen, where 3 filing cabinets stood against the wall, each one labeled by year. 29 years of water chemistry logs, signed field notebooks, chain of custody forms for water samples, a laminated certificate from the State Department of Natural Resources naming her wetland an official long-term monitoring site, and, propped against the wall, a single black-and-white photograph of a group of teenagers standing knee-deep in the marsh in 1998, clipboards in hand, grinning at the camera. "Every one of these children signed and dated their own entries," Eleanor said. "Several of them are lawyers now. One works for the EPA. I imagine a jury would find them rather more credible than a satisfied inheritance." Preston Vance's smile did not waver, but something behind his eyes did. "That's quite the collection, Mrs. Whitfield." "Isn't it?" Eleanor said pleasantly, pouring him more tea. "You should also know the wetland sits directly above the unconfined aquifer that feeds 3 of the 4 municipal wells serving Ashford Hollow. I imagine your hydrology consultants have already told you that, which is presumably why your client wanted to buy the land in the first place, 3 years ago, before any of this unpleasantness with the heron." Preston Vance set down his teacup very carefully. "I don't believe I mentioned anything about 3 years ago," he said. Eleanor smiled again. "No," she agreed. "You didn't." He left without an answer. $40,000, it turned out, was not nearly enough to make Eleanor Whitfield disappear, because Eleanor Whitfield had never intended to negotiate from a position of weakness in the first place. When money didn't work, Halden Agrochemical tried a different approach. Within a month, the gravel access road to Eleanor's property, a road she had used without incident for 40 years, was suddenly blocked twice by maintenance work on an adjacent right-of-way the company insisted it owned, despite decades of evidence to the contrary. Unmarked trucks began idling near her fence line at odd hours. Someone left the wetland's boundary gate open 3 separate times, allowing all-terrain vehicles to tear fresh mud tracks through a protected nesting area. A woman claiming to be a concerned Ashford Hollow resident started a rumor at the local diner that Mrs. Whitfield had been seen dumping chemicals herself, an accusation so absurd that half the town laughed it off immediately. Eleanor Whitfield had taught nearly everyone in Ashford Hollow under the age of 50. Most 70-year-old widows living alone at the edge of a rural county might have panicked, Eleanor instead went to the hardware store in town and bought 4 solar-powered trail cameras, the kind hunters use to track deer. She had motion-activated, time-stamped, weatherproof footage of every single incident within 6 weeks. The trucks, the ATVs cutting through the marsh. Even in one remarkably clean shot, the license plate of a contractor vehicle, registered to a subcontractor with a direct billing relationship to Halden Agrochemical. She did not go to the press. She did not call a lawyer. She simply labeled each video file by date, backed them up in triplicate, 1 copy on a hard drive at home, 1 in a safe deposit box at the bank in town, and 1 mailed, the old-fashioned way, to her nephew who worked in IT security 3 states away, and waited. Because Eleanor Whitfield understood something that Gordon Halden's expensive lawyers apparently did not. Intimidation only works on people who are afraid of being alone in a fight. Eleanor had spent 3 decades in classrooms facing down far more intimidating audiences than corporate lawyers. 16-year-olds who did not want to learn the Krebs cycle on a Friday afternoon. She was not afraid. She was, if anything, taking notes. 6 months into what Eleanor had begun quietly calling, in the privacy of her own kitchen, the Halden problem, a plain white envelope arrived in her mailbox with no return address. Inside was a single flash drive and an unsigned note that read, "You were my chemistry teacher's college roommate's daughter's teacher. I don't know if that means anything to you, but I couldn't sleep anymore. Please be careful." The flash drive contained internal emails, engineering reports, and cost-benefit memos spanning nearly 3 years, all originating from inside Halden Agrochemical's own environmental compliance department. The most damning document was an internal memo, dated 14 months before the heron died, written by a junior environmental engineer named Claire Sutton. In it, Claire warned management that the plant's aging wastewater containment liner had developed measurable seepage and estimated that a full liner replacement would cost approximately $2.3 million. Attached to that memo was a 1-line reply from a regional operations director. Approved cost too high for this fiscal year. Monitor and reassess in Q3. Q3 had come and gone, so had Q4. The liner was never replaced. Instead, discharge volumes were quietly increased to relieve pressure on the failing system, directly into the creek that fed Eleanor's wetland. It wasn't an accident. It was a documented, calculated decision to let contamination continue rather than absorb a repair cost that would have dented 1 fiscal quarter's earnings report. Eleanor read every page twice, made 3 physical copies, and then did something that surprised even her nephew when she called to tell him about it. She didn't send the documents to a lawyer yet. She sent copies to Dr. Sarah Bennett at the EPA, her former chemistry student, with a note asking only that Sarah confirm whether any of this looks scientifically significant. Sarah called her back within 18 hours, and for the first time in the entire ordeal, Eleanor heard something in a young scientist's voice that sounded very close to fury. "Mrs. Whitfield," Sarah said, "this isn't just significant. This is a federal case." It was Sarah Bennett who noticed the detail that would ultimately multiply the company's legal exposure by an order of magnitude. And it was Eleanor's own 3-decade data archive that made the discovery possible. Buried in Eleanor's monitoring logs from 2003 onward were repeated observations, corroborated by student field notes and photographs, of a small, secretive population of wood turtles inhabiting the marsh, a species that, unbeknownst to almost anyone in Ashford Hollow, had been formally listed as threatened under state law 9 years earlier, and was under active federal review for Endangered Species Act protection. Eleanor's students had been photographing, measuring, and logging individual turtles by shell markings for over 15 years without ever realizing the population's full legal significance. It was, in effect, the single longest continuous scientific data set on that particular wood turtle population in the entire state. The contamination hadn't just killed birds and fish, it had degraded critical habitat for a legally protected species. With 15 years of independently verified population data proving both the species' presence and its decline, coinciding precisely with the plant's documented discharge increases. What had started as a private nuisance and water contamination claim now involved potential Endangered Species Act violations, Clean Water Act violations, and, because of Claire Sutton's leaked memo proving the company knew about the failing containment system and chose not to fix it, a plausible criminal negligence referral. Preston Vance did not know any of this yet. Neither did Gordon Halden. They were still operating under the assumption that they were dealing with one stubborn old woman and a dead bird. Eleanor did not file the lawsuit herself. She hired a young attorney named Marcus Delaney, a former student of hers from the class of 2011, who had gone on to specialize in environmental litigation precisely because, as he told her over coffee, "You were the first person who ever made me care whether a river was alive or dead." Marcus took the case on contingency, structured through a small environmental law nonprofit, so that Eleanor would never personally bear the financial risk of taking on a company with Halden Agrochemical's resources. It was Eleanor's idea. She had also, months earlier, quietly established a small trust to hold any future settlement or judgment, ensuring that whatever money resulted from the case would go toward permanent wetland restoration and a scholarship fund for environmental science students in Ashford Hollow, a detail that would later prove impossible for Halden's legal team to spin as personal greed in front of a jury. The initial complaint, filed in federal court, named 3 causes of action: violation of the Clean Water Act, violation of the Endangered Species Act, and common law nuisance and trespass. Within days of the filing, 7 other landowners downstream of the plant, whose wells had shown unexplained contamination for years without any clear source, joined as co-plaintiffs once Eleanor's data made the connection undeniable. Gordon Halden's response, delivered through Preston Vance at a press conference on the courthouse steps, was confident, even dismissive. "This is a disagreement over water quality readings from an amateur monitoring station run out of someone's garage," Vance told reporters. "We are confident the science will not support these claims." He had not yet seen Claire Sutton's memo. He had not yet been told about the turtles. And he had absolutely no idea that Eleanor Whitfield's amateur monitoring station had, 4 days earlier, been formally certified by the state as an official reference site for regional water quality baseline data. Data the state's own expert witnesses would now be relying on in court. Discovery is where lawsuits are truly won or lost, and it was during discovery that Halden Agrochemical's case quietly began to collapse. Marcus Delaney, working with Dr. Sarah Bennett as an expert witness, submitted Eleanor's 29 years of chemistry logs as baseline evidence, cross-referenced against student sign-off sheets that made the chain of custody nearly impossible to challenge. Halden's attorneys tried to argue the data was inadmissible amateur record-keeping. The judge disagreed, noting the state's own certification of the site rendered that argument moot. Then came the flash drive. Marcus entered Claire Sutton's internal memo, and the operations director's one-line reply approving cost savings over containment repair into the discovery record. Halden's legal team scrambled to claim the documents had been obtained illegally. But Claire Sutton, watching from her own home 3 states away, made a decision of her own. She came forward voluntarily as a whistleblower, protected under federal environmental whistleblower statutes, and gave a sworn deposition confirming every detail of the memo herself. It was, Marcus later admitted, the single worst day of Preston Vance's professional life. In one afternoon, Halden Agrochemical went from disputing amateur water readings to defending a documented decision, made in writing, to knowingly allow toxic discharge into a federally significant wetland rather than spend $2.3 million on a repair. Halden's legal team tried one more maneuver during discovery, a classic delay tactic. They filed a motion arguing that Eleanor's decades-old easement and monitoring station designation were themselves invalid, claiming a clerical filing error from years earlier voided the land trust's authority. It was a technical, almost desperate argument, the kind lawyers file when they've run out of better ones. Eleanor had, of course, anticipated exactly this. 2 years before the heron ever washed ashore, on the advice of no one but her own careful instincts, she had paid a title attorney in the county seat $200 to conduct a full chain of title review and refile the easement documentation with corrected legal descriptions, simply because she'd noticed a typo in an old surveyor's plat map and didn't like loose ends. The motion was denied in 19 minutes. She fixed a paperwork error a decade before we even thought to look for one. One of Halden's junior associates reportedly told a colleague after the hearing. loud enough that Marcus overheard it in the courthouse hallway. How does she do that? Marcus, when he later relayed the story to Eleanor over coffee, asked her the same question directly. Eleanor just shrugged and stirred her tea. I taught teenagers for 34 years, she said. You learn very quickly that the only way to win an argument with someone who thinks they're smarter than you is to already be 3 steps past wherever they think the argument ends. And then came the twist nobody, not Marcus, not Sarah, not even Eleanor herself, had fully anticipated. Halden Agrochemical's environmental liability insurance carrier, upon reviewing the discovery materials, formally denied coverage for the claims. Insurance policies routinely exclude coverage for intentional or knowing environmental violations, and Claire Sutton's memo, along with the operations director's written approval to delay repairs for cost reasons, was about as clean an example of knowing violation as an insurance adjuster could ask for. The company's coverage, which might otherwise have absorbed a substantial portion of any judgment, evaporated overnight. Gordon Halden was suddenly staring down the barrel of unlimited personal and corporate exposure, with no insurance cushion whatsoever, a fact that his own board of directors did not take well. 2 board members resigned within the week. The company's stock, publicly traded on a regional exchange, dropped 19% in a single trading day once analysts got wind of the denied coverage and the Endangered Species Act exposure. Preston Vance requested an emergency settlement meeting. Eleanor, for the first time in the entire saga, agreed to attend in person. The meeting took place in a conference room in the state capitol, Gordon Halden himself present for the first time, flanked by 3 attorneys and a public relations consultant. Eleanor arrived with Marcus Delaney and, at her specific request, Dr. Sarah Bennett and Claire Sutton, a choice that visibly unsettled Gordon Halden the moment they walked in. Gordon opened with an apology, so smooth it might have worked on someone less prepared. He spoke of regrettable oversights, of his company's deep commitment to the Ashford Hollow community, and offered a settlement of $12 million, an enormous sum by any ordinary measure, clearly calculated to sound generous enough to end things quietly before the case reached trial and public record. Eleanor let him finish. Then she opened a folder of her own. She laid out, calmly and without raising her voice, the full scope of what a trial would expose. 29 years of unimpeachable data, a documented internal decision to prioritize profit over a known containment failure, a whistleblower's sworn testimony, a legally protected species in documented decline, contamination reaching a municipal drinking water aquifer, serving 4,000 residents, and now, a denied insurance claim that left Gordon Halden personally exposed under piercing the corporate veil theories his own attorneys had surely already warned him about. Mr. Halden, Eleanor said, you offered me $40,000 8 months ago to make this go away quietly. I'd like you to understand why that number, and this one, were never going to work. She slid across the table a single-page summary, prepared weeks earlier by Marcus and an environmental economics consultant, estimating the full cost of remediation. Dredging and removing contaminated sediment across 11 downstream miles of waterway, replacing the aquifer's compromised well infrastructure for the entire town, funding a 50-year wood turtle habitat restoration and monitoring program mandated under the Endangered Species Act, and covering the medical monitoring costs for downstream residents whose well water had been contaminated for years without their knowledge. The number at the bottom of that page was $1.4 billion. Gordon Halden actually laughed, the sound sharp and disbelieving. That's absurd. No jury awards that. No single jury needs to, Marcus said calmly. Federal Clean Water Act penalties alone run per violation, per day. You've been in continuous violation for at least 3 years, across multiple discharge points, with a documented internal admission that you knew. Add Endangered Species Act penalties. Add the co-plaintiff's property damage claims. Add punitive damages once a jury hears Claire's testimony read aloud. We're not asking for that number. The statute is. Gordon Halden's attorneys asked for a short recess. When they returned, Preston Vance tried one last maneuver, a version of the same trick that had failed months earlier, only larger. He offered Eleanor $200 million personally, structured as a private settlement paid directly and immediately to her, contingent on her withdrawing as lead plaintiff and instructing her attorney to drop the case entirely, framed delicately as closure at last, for a woman who deserves to enjoy her retirement in peace. It was, on paper, an almost unrefusable amount of money for a retired schoolteacher. Eleanor smiled the same patient smile she'd once used on students who thought they'd found a clever loophole in an exam question. "Mr. Vance," she said, "I established a trust 14 months ago. Any settlement or judgment in this case is payable to that trust, not to me personally, for the specific purpose of wetland restoration and student environmental scholarships. My attorney has no authority to accept a private personal payment on my behalf, and even if he did, I wouldn't take it. I'm not doing this for money. I never was." It was the single sentence that ended any realistic hope Halden Agrochemical had of buying its way out quietly. Because Eleanor Whitfield, unlike almost every adversary Gordon Halden had negotiated against in his career, had removed her own self-interest as a lever they could pull months before they ever knew they'd need to pull it. The case went to trial 4 months later. It lasted 11 days. The jury deliberated for 6 hours. Claire Sutton's testimony was, by every account, devastating. A young engineer describing, in plain and steady language, exactly how a $2.3 million repair had been denied to protect a single fiscal quarter's earnings, and exactly what that decision had cost downstream. Dr. Sarah Bennett walked the jury through 29 years of Eleanor's data, with the same patient clarity Eleanor herself had once used to teach freshman biology. And Eleanor took the stand for less than 40 minutes, answering every question in a calm, unhurried voice that Marcus later said was more persuasive than any cross-examination I've ever seen, because she never once raised her voice, never once appeared vindictive, and never once wavered from a single fact in 29 years of records. The jury found Halden Agrochemical liable on all counts. The court's final judgment, incorporating statutory Clean Water Act penalties, Endangered Species Act remediation costs, compensatory damages to the co-plaintiffs, and punitive damages tied directly to the documented internal decision to delay repairs, totaled just over $2.1 billion, the largest environmental judgment in the state's history. Gordon Halden resigned as CEO 11 days after the verdict. Halden Agrochemical's board sold the company's remaining assets within the year to satisfy the judgment, and the plant itself was shut down permanently, its remediation funded directly by the settlement trust Eleanor had established. Preston Vance, in a rare moment of candor to a local reporter after the trial, said only, "We never should have underestimated her. None of us understood, until it was far too late, that she had been 3 steps ahead of this company since before we ever knew her name." 5 years later, Sparrow Hollow is a certified wildlife sanctuary, its water quality restored to levels better than anything recorded in Eleanor's original 1990s baseline data. The wood turtle population, once quietly declining toward extinction, has more than doubled under a federally mandated 50-year monitoring program funded entirely by the settlement. The Eleanor Whitfield Environmental Scholarship, funded by the Trust, sends 2 Ashford Hollow students to study environmental science every single year, several of whom now spend their summers exactly where it all began, knee-deep in the marsh, clipboards in hand, logging data of their own. Claire Sutton left the chemical industry entirely and now works as an environmental compliance consultant, helping other companies avoid the mistake Halden Agrochemical made. Dr. Sarah Bennett was later honored by the EPA for her role in the case. Marcus Delaney's small nonprofit law firm has since taken on 11 similar cases across 3 states, citing the Whitfield case as the template. And Eleanor Whitfield, now 73, still walks down to the dock every morning with her thermos of coffee, watching the herons wade through water she spent 30 years quietly, patiently, and brilliantly, making sure no one could ever poison again without paying for it in full. She never raised her voice, she never lost her patience, she simply did what she had always done best. She paid attention, she kept the records, and she waited for the day her students, and her data, would prove her right. Reporters who came to interview her after the verdict often asked the same question, phrased a dozen different ways. How had a retired schoolteacher outmaneuvered a multinational corporation's entire legal department, seemingly at every single turn? Eleanor always gave some version of the same answer, delivered with the mild, unbothered patience of a woman who had spent her whole career explaining obvious things to people who should already have known them. Corporations like that count on one thing, she'd say. They count on nobody watching closely enough, for long enough, to notice the pattern before it's too late to stop. I just happened to have 29 years of practice watching closely. It was never really about being smarter than them. It was about being more patient than they ever expected anyone to be. On the anniversary of the verdict each year, Eleanor invites the current class of scholarship students out to Sparrow Hollow for a single afternoon. She hands each of them a clipboard, walks them down to the water's edge, and teaches them how to measure dissolved oxygen the same way she taught it decades earlier. Carefully, patiently, one small number at a time. Write it down, she always tells them. You never know, 30 years from now, exactly what it might prove.